My Lord, I appeal for the applicants.
Yes.
The respondents with my engineer, Mr. Narek. Lord, the respondent, the first, I beg your pardon, the first respondent from Nami, we have prepared heads of argument. May I leave to have the...
Well, before you do that, just inform me of a few things. There appears to be an application, and then there's another application.
There are 3 applications.
Yes, so there's only one in the file, and some papers of other applications.
Lord, let me...
And the papers run, the one I see is paginated from page 1185. Why is this a matter that must be dealt with in the urgent court?
we say it is not that, my Lord, that should be struck off the roll of the
It was struck off on the 20th of January.
Yes, and it was then not correctly placed on the roll. We say it's still not correctly on the roll. There are effectively 3 matters before your Lordship. They run to in excess of 2,000 pages.
Yes.
The one matter, the review application, is far from being rightly hearing, and it's so inextricably linked with the other 2 matters. But there's no manner,
Yes.
our respectful submission in which these matters could be decided.
Yes. Yes, why must this matter be... Look at the file. I mean, this is not the sort of matter that one deals with in the urgent court.
My Lord, maybe let me just give a context. There is an order that was made on the 9th.
Yes.
And that order...
On the 9th of what? On the 9th of what?
Of December.
Yes.
That order granted the applicants a leave to apply for the discharge.
Which applicants?
The applicants, the present one.
Well, what is the present matter? I don't know. There are 3 applications.
The junction part.
Junction parties, yes.
What's the importance and urgency of the matter before court, and why is it important for you guys to get the interim order that you're seeking right now?
The urgent application is to prevent violence against about 4,000 employees employed by the family. It's of imperative importance to make sure that we get an interim order. There are marches today, there are promises and threats of violence. It's extremely important for us to get an interim order.
And is there a reason why the application was done today specifically when the threats were done last week?
Yes, it's a very good reason. There is a threat of violence for today. In fact, in the City Press of Sunday, there was an article that says there's a surprise for the Guptas at the march today. And that's why it was launched yesterday morning for hearing this morning.
Now, Mr. Van der Merwe, why wait until today? Why didn't you guys do this on Friday, knowing very well that the march or the threats that you're rather stating in your applications might occur today? Why not on Friday?
No, you will note that I said the City Press article came out on Sunday. We drafted the papers on Monday morning.
Yes, and the fact that the EFF lawyer has repeatedly stated that the affidavit that they handed in does give the assurance that there will be no violence. Is that not enough support that maybe the matter is under control?
Not at all. You will recall, if you were in court just now, that the judge asked for an undertaking. They refused to give the undertaking. So we will persist with an interim order at 2 o'clock this afternoon.
Wat maakt Mickey Maritsi zo? Wat maakt hij?
Number 1, I will see the Up in completing this matter due to limited availability of Mr. Sadia, who is due to appear in Botswana court tomorrow.
I see. Yes, thank you, Mr. Maritz. Thank you, Mr. Semenya. Yes, Mr. Maritz.
Yes, my Lord, we have just before the commencement again, as a representative of the state attorney, the acting for the fourth respondent is a notice to abide, which I beg leave to hand up to Lordship, which I will ask attention, in which it is said that the fourth respondent will not oppose the application or abide the decision of the Honourable Court. So this is the original. Might I beg leave to hand that up together with the original farming papers, which are not yet on the file that was a copy, and also a 2-page replying affidavit.
Thank you, Mr. Maritz. Let me just see what I've got here. So shall I give you back the notice of motion and founding affidavit, which you say is a copy?
Yes, a copy. What I've given is the summary.
Thank you.
The Lord, if I may, as it were, cut straight to the chase, so God forgive me. The Lord, it's a matter of common perception and recognition in the courts that when one is dealing with matters involving, for example, defamation, incitement to violence, incitement to racism, that it calls for a value judgment by the court. There's no clear line drawn, as it were, in the sand where one can say it falls this side or that side of a particular line. It all depends on the circumstances and how the reasonable, right-thinking member of society would perceive or understand what is being said or done. Now, Lord, with respect, we have not only the fiction but the reality that the courts are taken to embody that reasonable or right-thinking member of society and are called upon to make that value judgment in a matter such as this. When authorities have dealt with the concept of a reasonable man, we have statements such as the reasonable man is not overly timid, not overly aggressive or robust, not oversensitive, but again, not prone to just let anything go. So Lord, weighing all those up, it appears to us that the essence of the respondent's response is to say, yes, everything that the applicants say we said, orally or in writing, we did say. There's no dispute as to what was written, what was said. The gravamen, it appears to be, of the defense is that no one would reasonably have understood that to be a call to violence or an incitement of violence or aggression towards the Guptas or their interests, their financial and economic interests. That's the essence of what is said. Now, also, of course, it said, well, this matter is not urgent because nothing is about to happen. I'm going to deal, of course, because we submit urgency is very much wound up with the merits of the matter. One can't deal with them, we submit separately. Well, the replying affidavit deals briefly with certain aspects not raised in the filing papers and which are a direct response to the essence of the defense. It addresses both the issue of urgency and the question of what is the public out there making of these statements. Now, Mr. Hawa has made a replying affidavit. He refers to the fact that in the Pretoria News and the Star newspaper, they owned by the same company, there was an editorial opinion which appeared on the 8th of February. That's yesterday. And if your Lordship will go to X1, it's just indicative with respect. We have an editor of a newspaper and the press we know in this country are fighters for the freedom of expression. In other words, people must be allowed to air their views. But here, leading newspapers in the country come and say, these respondents have overstepped the line, even from the point of view of an editor being a champion of freedom of the press. Your Lordship just, and we submit, that's with respect, inescapably, what Your Lordship and any right-thinking, reasonable reader of what was said of and concerning the Guptas would interpret the message to be, namely a call to violence against them. My Lord, the editorial X1 has a heading, Attack on the Guptas Unwarranted, in the Pretoria News. It says, last week we received a timely reminder of the need to reiterate the rules of engagement for what promises to be a robust election campaign this year for control of the giant metros and even the little town councils, the length and breadth of our country. Julius Malema, the Commander-in-Chief of the EFF, was sounding off on a range of topics, as is his inalienable right to freedom of speech. But in doing so, he began to overreach, straying perilously close to incitement and race hatred in his vitriolic attacks on the Gupta family. Whatever the Gupta stand accused of in the court of public opinion is for due process to resolve, not mob justice. We know what mob justice is a reference to. It's a reference to lynching, vigilante action. As naturalized South Africans, they have as much right to live and work here as Malema or any other South African. Then he continues to say the disbarring of journalists, and then in the next paragraph, and to openly threaten those journalists with harm if they tried, is simply unacceptable. So with respect, it's not fanciful to suggest that the message which was intended to be conveyed is in fact being understood as such outright. My Lord, then we have, again the respondents say, well, this application is all about trying to divert attention about what's happening in the Constitutional Court today. In the Constitutional Court today, there's argument being heard on the issue concerning Nkandla and the rights and scope of powers of the public protector. In general, that context. We've all seen it, it's a matter of public knowledge, the subject matter of that. Now, the Lord, photographs taken this morning outside the Constitutional Court are annexed. Your Lordship will see the first one annexed to these papers. On the right-hand side of the photograph, you'll see it's not the Constitutional Court. Concerning something else, there's the poster. Guptas must go.
I'm sorry, oh yes. Is that part of X?
Yes, we have X1, then we have X2,
yes.
And then comes the photographs.
Okay, they don't bear a number, but I found the number of photos. The first one as what you're referring to.
It's in paragraph 4, I send a few pictures. They
Yes.
don't have an annexure number. Now the first one is in the center, slight left, vote EFF, and then one below that has a thing directed at the president. Zuma, a pervert, a rapist, a thief. Then above that, Guptas must go. And then left, one can also see against the left-hand margin, Guptas must go. So, central in what's happening today in the protest action and the picketing outside the Constitutional Court are the Guptas. Then, next one, we have Ward 135. That's the EFF ward. The radical branch. And then on that,
Shall we mark these just to make it easier?
X3,
The first one that you're...
X4,
Yes.
X5 and X6. And we're on X4, again happening today.
I'm sorry, let me just see. I've now made a mistake here. X3, 4, 5 and 6. Right, I've got that.
So my Lord, there we see on this poster of Ward 135, which advertises itself as the radical branch, just above the 135, you'll see again the poster of the Guptas in the background. You just see the word Guptas. But then left, the person holding the banner on the left-hand side of the photograph, honeymoon is over for Guptas. Then X5, Then you see written over there, Main Safar. Now we all know who Main is. He's the new leader of the ANC Youth League. Then it says, we will stop war with war. Then hashtag Guptas must go. And the next one, and of course, it's said in the affidavit, Mr. Malema is there today. He's there with this crowd, addressing this crowd at the Constitutional Court. He's there on the site where this is happening. There, the poster, Malema ready to die for land. So we'll fight war with war. Mr. Malema ready to die for his land. Guptas must go. So as we are here in the court, after this morning's adjournment and until this afternoon, this is what is happening. It touches on the question of apprehension of harm, a reasonable apprehension of harm. Lord, then, again, I'm just putting up, as it were, certain skittles which appear to be the cornerstone of their submissions, and before I go to the particular words used. Then, Lord, your Lordship would have seen in the answer, let me just give the Lordship a page number, to say that the EFF wishes to eject. They wish to eject the Guptas from South Africa. And they say, well, there's no violence in saying that they must leave the country. It's paragraph 23, for example. Last sentence.
Are you now in the founding? Are you now in the founding affidavit?
No, the answering affidavit is paragraph 23. Paragraph 23. And we'll come back to the actual words, but the refrain in the answer is somewhat the following. The allegation made in this paragraph is preposterous. There is no violence in saying that the Gupta brothers must leave the country. Nor is there any violence in stating that South Africa is not for sale of curry. I insist in the call of the EFF that South Africa is not for sale. The EFF has never advocated for the expulsion of Indians. That comes back to the question of racism and xenophobia, because the Guptas are of Indian origin. It has called for the expulsion of one family. Now, might I point out, over and over, they talk about expulsion, and then the third last line, however, there is no necessity of evicting the Gupta brothers by force. We'll come to that. No necessity of evicting them by force. The EFF will not be involved in any such activities. It continues, however, to campaign for the ejection of the Guptas from South Africa. And Lord, we also can go to any dictionary. The primary English language meaning of eject is to throw out forcefully. They choose over and over to use the word eject. Not to deport, but to eject them from South Africa, which means to throw out forcefully. It's not a slip of a word, because it's a word which is the repeated refrain. But then they say, at other places, that they are entitled to engage, as paragraph 33 is a prime example. Paragraph 33. The allegations contained in this passage do not show any threat of violence, and we'll come to it. The EFF will act lawfully, including marches, petitions, and, if necessary, legal proceedings, to force out the Gupta family out of Gauteng. In other words, force. They're talking about to force them out. Not to use legal process, but to force them out. So the last resort, even on their version, is finally, if necessary, legal proceedings. But my Lord, they have a problem there. This version, this defense that we in fact intend to follow the law cannot be sustained on the basis of any level of credibility. based on the facts which they raise in these papers, it's not conceivable that any legal representative, being versed in South African law, could have advised that there's a legal process available to force the Guptas out of the country. I want to refer your Lordship to the South African Citizenship Act, 88 of 1995. Now, it's common cause that the Guptas are Indian by birth and heritage, that they have settled in South Africa, that they are naturalized South African citizens. So not by birth or descent, but by naturalization. Now, Section 8 of the Act, dealing with deprivation of citizenship, in sub 1, provides the following. The Minister may, by order, deprive any South African citizen by naturalization of his or her South African citizenship if he or she is satisfied that A, the certificate of naturalization was obtained by means of fraud, false representation, or the concealment of a material fact. And then or B. Your Lordship will note that all three jurisdictional requirements require intent to mislead on the part of the applicant. Fraud, false representation, concealment of a material fact. So it's not merely non-disclosure of material facts, it's concealment, which requires intent, false representation, or fraud. There's not one primary fact alleged which would put the Guptas in that category. So the jurisdictional requirement for the deprivation of their citizenship by naturalization is lacking on the answering papers. And of course it's the Minister who's the only one vested with the power to do it. A court cannot do it. So there's no legal process which can be followed. Because a court does not have the competence to take it away, only the Minister does, and of course the Minister doing that would be required to follow a fair administrative process. It would be an administrative decision protecting the rights, etc., and it would be justiciable by the court in review proceedings by any aggrieved party. And then the B, or such certificate was granted in conflict with the provisions of this Act.
Just repeat that.
B is if such certificate was granted in conflict with the provisions of this Act or any prior law. Now, of course, it can't be a prior law because of the date. This is a 1995 Act. So it would have to be otherwise in conflict with the provisions of this Act. It had to have been granted in conflict. And then Section 5 deals with how does one get a certificate of naturalization. It says the Minister may, on application in the prescribed manner, grant a certificate of naturalization as a South African citizen to a foreigner who satisfies the Minister that. Well, there's no suggestion that in any of these respects the Minister erred in law or acted beyond his or her powers at the time in granting it. It's merely an allegation. We will take law, we will picket, we will protest, we will do whatever we want to, and we will raise a large hue and cry to force them out of the country, to eject them from the country, and if necessary follow legal process. There is no legal process that a citizen can follow against another citizen to remove their citizenship. Against that background, Lord, if one needs to then go to the, if one goes to the particular allegations made, and one needs to test them against not what does the writer say are meant or intended to convey, what would the reasonable, right-thinking member of the public make it? Page 46, Annexure B. And before I commence reading this, what the Lordship would find that we submit, would find significant, is the answering affidavit is deposed to by the first respondent, Mr. Malema, no affidavit by the third respondent, and Mr. Malema never talks about himself. He always talks in the third person about the EFF, the second respondent. Now, it's common cause on the papers, his position in the EFF, he's the leader of the EFF. It's common cause on the papers who the third respondent is. He's in particular has a leadership position as a spokesman in Gauteng. His affidavit says, Mr. Malema, paragraph 1, I'm cited as the first respondent, but opposed to this affidavit for and on behalf of the second respondent. And then throughout, he refers to 5. It is apparent that the main concern of the applicants is the allegation that I, together with other members of the EFF, have incited imminent violence against the applicants, etc. Then he proceeds to say 6. The EFF has never threatened the applicants. Proceeds to say the EFF has never done this, the EFF has never done that. But one thing he doesn't ever say is that I did not intend to incite violence or incite hatred against the applicants. So if we go against that background to B at page 46. We start with the Guptas in India, page 46.
I'm just looking, my papers don't seem to be paginated, the answering affidavit.
Can I give back the one that we unhanded, unfortunately, from the research? Some reason the original was not paginated. I apologize. So the Lordship can keep a copy. The copy has got the page numbers on it, but the original is correct.
Do you want me to give you the copy back?
No, Your Lordship can keep the original, but I'm giving Your Lordship a copy because
Oh, I
it's got
see.
the numbers on it.
Because of the pagination.
Got the pagination.
Yes, thank you, Mr. Miritz.
The record of the original is paginated.
Right. You say page 46.
Page 46 is Annexure B. This is the 6th February statement. Now, of course, important because the 6th February statement is the one which gave rise to the editorial. The editorial concerns statements made on Thursday.
You're now referring
No, sorry,
to the
6th is Saturday. Sorry, it concerns the ones made before that. I'm looking at number B, page 46. This is the 6th.
Yes. Are you saying this is the one that gave rise
No,
to the Pretoria?
one before that gave rise to that, I corrected myself, because the one which gave rise to it is the one referred to which was before that. I'll tell your Lordship. Page 20 of the paper, paragraph 34, under the heading unexpected attack by the respondents. That's the one which gave rise to the press editorial.
You mean the one in the Pretoria
Yes,
News?
the one in the Pretoria News. That's the one which says on Thursday, 4th February, the first respondent appeared on national TV via a press conference hosted by the second respondent. All not in dispute.
Where do I find that?
Page 20, paragraph 34, founding papers.
Oh, yes.
I needed to start just before B, correcting myself.
But is that press statement somewhere in the, not the press statement, but the, what is alleged in paragraph 34?
34.
Is there an annexure there?
His number, Lord, it says a USB device containing the press conference will be made available. I'm told it's about a 40-minute interview. We have it available. But what we want to rely on, we've raised in the papers and has not been disputed. So we have it available, but what we've relied on, it said appeared on national TV via press conference hosted by the second respondent, which the first respondent lashed out at the Gupta brothers and their commercial interests with a clear and unambiguous threat of violence and xenophobia. Well, that's also how the editor of the Pretoria News and the Star understood it. That's what the article says. 35. The press conference was held at about 12 o'clock, and the recorded version is not only available on YouTube on the internet, in other words, it's publicly available and disseminated, but I'll also ensure that a USB device containing the press conference is made available to the court, from which the threats of the first respondent are clear, and I will have that handed up. The threats were aggressive, repeated, and inciting. And then 36, amongst others, the first respondent promoted violence against the Gupta brothers and any commercial interests held by them by stating that they should leave the country. Well, of course, that refrain in even stronger terms is in the answering affidavit. They must be ejected from the country. South Africa is not for sale over a plate of curry. It's admitted that that was said. The first respondent further stated that the Gupta brothers and all their businesses, directly or indirectly, will be removed from South Africa by whatever means. He was clear on this point. 38. The first respondent accused the 7th and 8th applicants of being a cartel, with the only objective of looting state resources, and he banned any journalists of the 7th and 8th applicants to cover any events involving the second respondent. That was directly addressed in the editorial opinion, to which we've referred in the reply matter today.